Hearing the appeal SM Algeria against Entry Clearance Officer UK Visa Section.
My lady, my lords.
May we begin by asking whether there ought to be an anonymity order? As I understand it, you don't think one is necessary, and you're leaving it to us to decide whether there should be an anonymity order.
We have taken instructions from the father who's in court, and his instructions are he's quite happy not.
Where is he?
And the gentleman has indicated that he has no objections to his daughter being named. And it's for that reason we sent a note that we are quite content for there to be no anonymity.
And I imagine that the Secretary of State is similarly neutral.
Indeed, my lady, yes.
Yeah. Yes.
It's unusual, but I think no anonymity.
I think, yes. Admittedly, of course, it concerns a very young child, where normally we do make anonymity orders, but it's always much more satisfactory to think of a child as a real person and name the child rather than by initials. So my lords are content that we will not make an anonymity order in this case.
It is our preference. I'm most grateful. My learned friends, Mr. Brian Kelly, Queen's Counsel, together with Van Lask, appear on behalf of the respondents, and I appear on behalf of the appellant, together with Mr. Moomin, Katie Williams, and Ms. Smeaton. Before I make my submissions, I understand that the Secretary of State, or at least the respondent, Mr. Kelly, wishes to make an application to you, having thrown an unlit firecracker into the den on jurisdiction. May I sit down whilst he makes it?
Yes.
My lords, my lady, on the question of jurisdiction, you will have seen that in our written case, we mentioned the Sala judgment of the Upper Tribunal, paragraph 79, and we said that we didn't take that jurisdiction point in this appeal. However, as you've seen, the appellant has said that the point can't be avoided, and on reflection, we agree with the appellant. The Supreme Court can't avoid determining the question as to whether it has jurisdiction to entertain the present appeal.
What's the current status of the Sala decision? It's an Upper Tribunal decision.
It has not been appealed, my lady.
It has not been appealed.
It has not been appealed. And it has been reflected in the 2016 Immigration EEA regulations. So the most recent immigration regulations now reflect expressly the interpretation of the regulations in the Sala decision.
And there's been no reference to Luxembourg?
No reference in relation to the Sala decision,
Yeah.
but there has been a reference in the Bangor decision, again referred to the very end of our written case. In January 2017, the Upper Tribunal, really as an afterthought, and I can take your lordships to that, made a reference to CJU on the question of whether the Sala judgment was compatible with Article 3.2 of the Citizenship Directive 2004.
When you say that the decision is now reflected in the 2016 regulations?
Yes.
In what form? What do they say?
Well, of course, the Sala judgment simply interprets the regulations, but now the definition of an EEA decision has been amended to make crystal clear what the Sala judgment has found, which is that these kinds of decisions from external family members are not appealable decisions for the purpose of the regulations.
Right.
So, my lords, if I may very briefly address you on how we have agreed, subject to your lordships, the jurisdiction.
Well, you've only
point.
got half a day for us to hear this whole case. We did discuss it ourselves and formed the view that because this was a matter of doubt, clearly in the light of the reference, we would propose to deal with the substance of the case, regardless. I mean, obviously, Sala isn't under appeal to us, nor is Bangor under appeal to us. So we have no jurisdiction, in a sense, to determine that matter. I suppose we can take the jurisdiction point of our own motion, in which case we're going to need probably to adjourn this hearing so that we can have full argument on the matter.
My lady, may I present to you our agreed proposal, which happily coincides in part, I think, with your ladyship's view. On the basis of the Constitutional Reform Act, Section 40, and your own judgment, my lady, in the Reed D judgment in 2016, the jurisdiction point in our submission cannot be avoided, and therefore it does need to be taken by your lordships. It plainly cannot be taken today for the reasons my lady gives, and therefore our agreed suggestion is that the jurisdiction point be adjourned and addressed separately following written submissions from the respondent, because we haven't addressed it in writing, and to which the appellants will, of course, have an opportunity to respond. And in the meantime, today, we continue and address the substance of the appeal, which we are here prepared to address. But of course, your lordships will no doubt want to reserve judgment on the substance until you've determined the jurisdiction point. If, of course, you find that the jurisdiction point is not, as Sala found, you will need to address the substance. So it's worth addressing it today. That's an agreed position, which I've discussed with Mr.
A
DeMello.
position agreed between you, yes. But I have a feeling that we ought to adjourn briefly just to see whether we agree with you. We have decided that we will proceed to hear submissions on the substantive point and reserve our position on the jurisdiction point. This is partly because, obviously, the expense of everybody preparing for today's hearing has already been incurred, and it would be a waste of everybody's time and energy not to proceed to hear this extremely interesting argument. We would like to know more about the reference in the Banger case. Did it involve a child?
No, my lady, no. The Banger reference is in Authorities Bundle 2, behind tab 25. Facts are stated briefly at paragraph 2.
Paragraph 2, yes. Yes.
And if I may, the Sala point is addressed only at the very end of paragraph 14, where one sees the upper tribunal recording that post-dating the hearing of this appeal, a differently constituted chamber of this tribunal decided that a person who's refused a residence card as an extended family member has no right of appeal. And they make the point that if that's correct, the respondent has no right to pursue the appeal above. And following that very brief observation, the upper tribunal, over the page at the very end, at paragraph 4.
Can you give me the electronic number for that, please?
Oh, forgive me, it's MS 1082.
1082, thank you.
So question 4 is in effect our question?
Yes.
Yes.
On the,
Yes.
on the compatibility point.
And this was a reference made by Mr. Justice McCloskey
Yes.
in January.
Yes.
But it didn't concern a child.
No.
So one of the issues for us is whether we should also make a reference on the same point. As this case concerns a child, we could ask the Luxembourg Court to expedite the hearing of the reference.
Indeed. Yes, my lady.
And that would be to everybody's benefit.
It certainly would.
Yes. So we are reserving our position as to what we do about the jurisdiction point, but obviously we will ask, clearly, you for more than a page of submissions about it. And no doubt Mr. DeMello will wish to respond to that. What sort of time scale?
We could certainly prepare our written submissions before Easter, in view of the urgency. I'm just turning to my clients because, of course, I will need instructions. That's part of the difficulty. So I'm instructed to ask for 4 weeks from today.
4 weeks from today. And you've already responded at some considerable length, Mr.
We
Shanahan,
do. I would ask just for 2 weeks.
2 weeks after that.
I'm certain we'll finish it within 2 weeks, but 2 weeks.
Yes. Very well. We'll do that. And then we'll decide what we're going to do in the light of those and further consideration. We may or may not want another hearing. We'll just see.
I'm grateful.
Thank you. Right. Well, somewhat late in the day, we can now get down to the substance. We will give an extra quarter of an hour to the hearing.
I'm most grateful. We should finish within time, at least from our side. May I say, before moving on to the submissions, that in Sala, as I understand, the appellant in that case was issued a residence card, and so it didn't proceed any further. If I could invite my lady and my lords to turn to the core volume, to the Statement of Facts and Issues, MS 59. At paragraph 5, my lady, my lords will see that in that paragraph, and I'll take you to the witness statements which were before the FTT, they lived in Algeria for a lengthy period, and if you turn, keeping your finger on MS 59 to MS 325, which commences at MS 324, the statement of the father, which was produced before the FTT, and looking very quickly at the first sentence in paragraph 8 and 9, one sees that they had to reside in Algeria for a period during which time the authorities had assessed their suitability to be guardians. The next is the witness statement of the mother at MS 331, but more particularly, it's paragraph 9 at MS 332. Then the next document that I'd ask you to look at is MS 359, the guardianship document which is dated, you will find over the page at 396, the 28th of September 2010.
Yeah.
And on page 359, towards the bottom left, the child's name, Mubarak Sarah, and below that, the child is put under the guardianship of Mr. Nabil. The next document is dated the 22nd of March 2011, and it's MS 362.
Sorry, say that again, please.
MS 362, a document dated 22nd of March 2011, and you will find the reference to the date in the top left. And basically, this is a legal custody deed on page 363, right on top, stating that the beneficiary of the legal custody has to give an Islamic education to the child put into his custody, keeping her fit physically and morally, supplying her needs. It's in the top, page 363, MS 363, and the rest of the paragraph, treating her like natural parents, protect her, defend her before judicial instance, assume civil responsibility for detrimental acts, authorize the beneficiary of the legal custody to get family allowance, and so forth, and allowing the child to travel outside Algeria. And the minor will be free to manage affairs after coming of age. Then, if I could ask you to look at a document which was not before the FTT, but was before the upper tribunal, MS 315, It's a document dated the 9th of January 2014, prepared by a clinical psychologist, Mrs. Dalila Sela. And you will note in the fourth paragraph, second sentence, that the couple, after 18 months of expectation and a vigorous social and psychological investigation, inquired by the social worker, documents that I have myself read, who asserts that a couple is capable of adopting the child, Sarah, because they correspond to the necessary criteria to be able to benefit from an adoption. Now, those documents that she herself read, of course, are confidential documents and would not be disclosed by the authority inasmuch in the same way as documents concerning our children in this jurisdiction would not be disclosed. Then, if I could ask you to turn to our written case, which sets out the Algerian law, and we do have a translation of the relevant code. It's MS 73 from
In your case, Mr.
in our case. And at paragraph 21, may I please invite you to read to yourselves the articles 46 to 124 on pages MS 73 and 74.
Yes.
Well, of course, we have read this
Yes.
before the hearing, so we're obviously familiar with its content.
I'm sure, but
We don't need to reread it.
that's all right. May I just quickly then proceed to the FTT's determination, which touches on the subject of rigorous assessment, looking at MS 112.
112.
Yes, 11, sorry, beg your pardon. It's 162, I beg your pardon. The determination commences at 154, but I'm looking particularly at paragraphs 34,
33 and 34.
33 and 34, yes, starting at MS 161. At paragraph 32, they refer to the legal custody order. And at MS 162, first line, paragraph 34, there was no rigorous assessment in Algeria. There was no challenge in relation to both the father's and mother's witness statement that they had resided in Algeria for a lengthy period. And that is, to a certain degree, corroborated by the clinical psychologists who dealt with that particular aspect. The judge does, however, on page MS 162, refer to the case through the lens of the immigration rules in Article 8 at paragraph 38. And she applies the Raska principles to the case. If I could then move on.
Forgive me, Mr. Zeller, are you asking us to depart from the findings of the first-tier tribunal, paragraph 34, or not?
I am asking you to treat it with some reservation. When she does refer there was no rigorous assessment, I assume she's referring to the period of residence there and vetting.
But what she's actually doing is addressing the assertions in the English social workers report,
Yes.
which didn't appear to have any evidential basis.
And that commences at paragraph 31, MS 161.
Yeah.
And I would think that my Lord Hughes is correct that the first sentence in paragraph 34 is directed to that report. But I want to make our position clear that the parents had resided in Algeria for a period. Then if I could ask you to look at the upper tribunal's determination, which was incomplete in the core volume, but is set out in the supplementary bundle, having discovered that it was incomplete. We inserted it there, and it's in the second supplementary bundle, tab 15, and I'll take you directly to the relevant paragraphs, which is at SSB 10.
Loose copies of this were provided.
Yes.
I'm working from a loose copy. I'd be grateful for your identification of paragraph numbers, please, Mr. de Mello.
Paragraphs 19.
Thank you.
What they said, having looked at the term that under Article 3.2, the last sentence, on the facts of this case, we are satisfied that the appellant is a family member of the sponsors. She has no other family of whom she is aware, and they, or at least Mr. and Mrs. Medouin, are the central figures in her life. 20. The refusal to grant the appellant entry clearance is currently impacting upon the free movement rights of Mrs. M, because if you recall, mother was living with Sarah in Algeria.
Is she still living there?
No, the present position is she is in France, she has been issued a family residence permit, and she's in the process of applying for French citizenship.
I see.
What, she's in France with the
mother.
With the child?
Sarah is with
Sarah's
the mother.
with the mother.
Sarah's with
I beg your pardon, yes.
And Sarah's applying. I mean, the mother already has French.
She has, yes. But Sarah has been issued a family permit and is living there, but she cannot come to England where the father
quite.
works. But the reason I'm drawing your attention to paragraph 20 is because there has been a finding that there is and has been an impact on freedom of movement, which might be relevant on the question of a reference with reference to Salah. That is, a child who and the mother cannot join the father exercising community rights, and if for any reason Article 3.2 doesn't apply, then the father would say that Article 20 and 21 of the Citizens Direct of FEU would apply, together with his right to exercise community rights to work. If I could then ask you also to look at MS 264. MS 264 were the grounds of appeal which commenced at page 263, advanced by the Secretary of State in relation to the upper tribunal's determination. And on page 264, paragraph 8.
I'm very sorry. Can you give me...
Yes, MS 264.
I'm just checking whether... No, this
Is that the second page of a letter of the 2nd of June?
That is right, yes. And I'll invite you...
I'm sorry, I don't have the core volume with me,
Yes.
so I need the appendix page numbers.
Yes.
Because my electronic bundle isn't working.
128. Try 128.
128, yeah.
Thank you very
128.
much indeed.
I'm ever so sorry.
No, it's not your fault. It's our electronics aren't working properly.
And if my lady turns over the page, and if you look particularly at paragraph 8, one of the grounds had suggested the potential risk of abuse. And the response to that by senior immigration judge Allen is at my lady's page 129, but MS 265, in refusing permission, the second sentence addresses the complaint about the potential risk of abuse.
Mr. Mello,
It's all ancient history, isn't it?
But the point,
Mello?
I agree, but the point is we want to make it absolutely clear if there's any suggestion that by allowing a child such as this, Sarah, it somehow exposes the national scheme to distortion of that scheme by abuse, that certainly is not a point which can be raised in this particular case.
Why not?
Because the immigration judges found that Sarah lives in a loving family.
This child does, yes.
But rejected any suggestion that this arrangement could in any way amount to an abuse.
You mean there's no abuse in the present case?
In the present
I
case.
thought.
Mr. Mello, I must say I'm completely at sea as to why we're talking about risk of abuse, whether the rigor of assessments for kafala in Algeria are comparable to the rigor of assessments for adoption in this country, and so forth.
Certainly.
Are we not simply dealing with regulations, UK regulations, which have to be construed compatibly with a European directive?
Certainly.
And if not compatible with it, so much the worse for the regulations, because the applicant is entitled to rely on the directive itself.
That's right.
And the directive uses an expression, other family members.
That's right.
And the basic issue is, does that expression cover this child?
That's right.
That's it.
And,
My Lord,
I thought then the issue might be, is that an expression with a meaning in European law,
Yes.
or is it simply to be applied by member states in accordance with their own understanding of what family members comprise? And presumably it has to be applied compatibly with the Charter of Fundamental Rights and Freedoms.
That's right. My Lord, I'll deal with that point directly, but having exhausted my reference to the facts, I was going to take my lady, to the international instruments and then directly to Article 3 and our interpretation of Article 3. So it should be a pretty short summary. I don't propose to go through our written case because it's there for you to have read, and no doubt you would have read. If I could ask you to go to the international instruments, and the purpose of my drawing your attention to the international instruments is to stress that kafala has a particular and special place within the framework of protecting children's best interest when children are put either into care or are placed into guardianship arrangements with the legal guardian. In the first if I could ask you to turn to tab 1, MS 425, sorry, volume 1, I think.
Mr. De Mello, we're dealing with European legislation here.
Yeah.
Now, the preamble contains no reference to the Convention on the Rights of the Child. If this were being considered by the European Court, would it not be concerned not with UN conventions, but with the European law itself, its recitals, and the context, including the Charter, in which it has to be construed?
My Lord, the European Court of Justice would take into account the international instruments as part of their juris in order to interpret the term other family member and to see if in any way it would be in conflict with their international obligations, the member states' obligations. And I can deal with it swiftly because we have dealt with it in our written case at paragraphs 45 and 46 onwards at MS 82, and I have set out the reference to the international instruments commencing from paragraphs 45 to 50, and the point that we make is summarized at paragraph 56. But for my purposes, I would like to draw attention particularly to what we have said in paragraphs 47 with reference to Article 20.3 and with reference to our written case at paragraph 50. And if I could summarize that position, having regard to these instruments, is that kafala is an appropriate and permanent solution for children such as Sarah, who is orphaned and abandoned, and whose choice of law does not permit adoption. And if I then go to the seminal part of the case, which is the interpretation of Article 3.2. But I would ask you for note-keeping purposes, looking at paragraph 50 of our written case at 83, that my lady, my lords, regards Article 12 on MS 446.
Article 12 of?
This is page 446. It's a reference to the guidelines for the appropriate use and conditions of alternative care for children, with particular reference to kafala.
Just hang on a minute. What is this? Guidelines, resolution adopted by the General Assembly, is that?
That is right, yes. And if you note at page at MS 444, the purpose of the guidelines at paragraph 1.2, or paragraph 2A, what we have cited in our written case, to support efforts to keep children together and to treat it as a permanent solution, including adoption in kafala of Islamic law. And again, on page MS 446 at number 12, the emphasis being permanency in the relationship between child and parent.
Paragraph 12 you're relying on, eh?
Yes.
Right.
Can I now turn to the Article 3, Article 2 and 3, which is in our found at MS 683. Tab 9. Starting off with Article 1, A, the conditions governing the exercise of the right of free movement and residence within the territory of the member states by union citizens and their family members, as a reference to family members and not to other family members. But the definition under Article 2 sets out who the family members are. And Article 3 relates to the beneficiaries. This directive shall apply to all union citizens who move to or reside in a member state other than that of which they are a national, and to their family members as defined in point 2 of Article 2 who accompany or join them. And without prejudice to any right to free movement and residence the persons concerned may have in their own right, the host member state shall, in accordance with its national legislation, facilitate entry and residence for the following persons. A, other family members, irrespective of nationality, not falling under definition in point 2 of Article 2, who in the country from which they've come are dependents or members of the households of the union citizens, having the primary care for residence, or where the union's health grounds strictly require the personal care of the family members by the union citizens. B, the partner with whom the union citizens has a durable relationship duly attested, and the host member state shall undertake an extensive examination of the personal circumstances and shall justify any denial of entry or residence to these people. Firstly, there has been no Court of Justice case on the point that we are directly concerned with. The case that throws some light on this is the case of Rahman, which is in volume 4.
Well, I'm sorry to be behind, but is it your case that you fall within 3.2 or 3.1?
We fall under 3.2A.
3.2.
328.
That's what I thought. Right.
Sorry, after you.
In which event there is a modified obligation on the host member state, is that right?
That is right.
To facilitate by undertaking an extensive examination, etc., and justifying any denial.
That is right.
Got it. Thank you very much.
Before we move to Rahman, are we not supposed to be reading Article 3.2 in the light of Recital 6?
Certainly. We have in order to maintain in the unity of the family in a broader sense and without prejudice the prohibition of discrimination on grounds of nationality, the situation of those persons are not included in the definition of family members under this directive and therefore do not enjoy an automatic right for entry and residence should be examined by the host member state on the basis of its own national legislation in order to decide whether entry and residence could be granted to such persons, taking into consideration their relationship with the union citizens or any circumstances such as their financial or physical dependence on the union citizen. Now, the point of the margin of appreciation or discretion conferred upon the national state in deciding who other family members are is not open-ended, and I will draw attention to the case of Rahman to support those propositions. There are limitations as to the category of members that they define, as to the criteria which they could apply in deciding which members should be granted admission or not. But there is an obligation to facilitate their admission.
Well,
And
what does that mean, Mr. McDermott, you say?
Yeah.
Does Recital 6 demonstrate that in relation to other family members, that is to say those who fall within 3.2a, as you say this little girl does the recital indicate that whether they are to be admitted or not is to be left to the basis of national legislation?
To a degree, it's left
To a degree. Right.
And as I say, it's not an open-ended margin of appreciation that they do have. There are constraints imposed upon the member states. And those constraints have been touched on in the case of Rahman, right. And we get some guidance in that case. Rahman is in volume 4.
No, it just occurs to me, just before we turn to Rahman, as well as in Recital 6 could be read as indicating that financial or physical dependence doesn't in itself render a person a family member. And that might be thought to be consistent with Recital 5, which defines family member as including a registered partner if the legislation of the host member states treats registered partnership as equivalent to marriage. So the implication of that would seem to be that simply being de facto a person's partner wouldn't in itself qualify you as a family member if your status wasn't recognized by the national law.
My Lord, I'm not certain if that's, yes, not in a sense, it's for the host member state to undertake an inquiry if there is a durable relationship. But having satisfied that there is a durable relationship, there is an obligation imposed upon the host member state to facilitate the admission. And one gets some.
Where have you got durable relationship from?
Aren't we, for the purpose of my Lord's question, recognised partnerships are included in Regulation 2, Article 2.
Yeah.
Article 2.2b.
Right.
Ah, yes.
So that treats them definitely as a family member.
Yeah.
We're, of course, concerned with who might be included in other family member.
Well, 2.2b treats them as an other family member, doesn't it?
No, as I understood.
Well, it treats them as the category for whom there is the modified obligation.
Oh.
No, under 2.2b.
2.2b treats them as a family member.
As a family member.
3.2b, yes.
Yeah. No, 3.2b, and I understood Lord Reed's question to be directed to 3.2b, with reference to those in a durable relationship as opposed to those who fall within 2.2b, the partner with whom there is.
Yes, right.
We're talking about beneficiaries rather than family members.
Yep.
Right.
In 3.
Yes.
But with reference to the nature of the examination of those under 3.2b,
Well, doesn't matter.
for what it's worth, I ought to point out that there is mention of it under Article 10.2, looking at Article 10.2e and F, that national member states may require proof of the relationship, that's E, and dependence, and F, proof of the fact there is a genuine relationship between the partners.
I'm afraid I've been misreading this, Mr. De Mello. So other family members within 3.2b have to be, well...
No, they don't.
It's very confusing.
Well, recognised partners, legally recognised partners are 2.2b, is this right? And other partners are 3.2b.
That's right.
And the position is that those who are family members have an automatic entitlement.
Quite.
Those who are other family members don't have an automatic entitlement, and they have to satisfy criteria which host member states may impose.
Mr. De Mello,
Yes.
3.2b, the partner with the durable relationship. Why, on your construction of 3.2a, doesn't that partner with the durable relationship come in at A? Why isn't he an other family member who is a member of the household of the Union citizen?
The reason we respectfully say that there is that divide found in 3.2a and b is that a cohabitee falls to be treated differently from an other family member where there is not that same level of relationship, that's cohabitation. So it's the point that cohabitation is the stark criteria which differentiates the groups.
Right, I see. So am I understanding the structure of this? That Article 3.1 applies to family members as defined in Article 2.2.
Yes.
The rights which one finds in subsequent chapters, rights of entry and so forth.
That is right.
And then 3.2 is saying that even where there are no such rights, other family members who are not family members as defined in Article 2.2
Yes.
are to have their entry and residence facilitated.
Yes.
And any refusal justified.
Yeah.
And
Of
any
course, another answer to my question as to why 3.2b is there, why the partner has to be put in a separate compartment, is that 3.2a is dealing with family members by the blood link.
That is certainly one interpretation, and we have addressed that point in our written submissions, that it would be too narrow approach to limit it to blood link. And I respectfully submit that I find some support for our case in the Advocate General's opinion in the case of Rahman.
You would like to go there, wouldn't you, Mr.
You've been trying to get
trying
to
to
the
get
mark.
us there for the last quarter of an hour, I think.
Well, I would have liked to have started with it because
Which tab is it?
It's tab 42. I want to take you there because otherwise I'll tie myself in knots. So I'm trying to get as much clarity as I can from the case. My learned friends will put a spin on it differently, but there we are. 42, and that's... If I could first ask you, MS, to look at MS 1585, and the first few lines gives you an idea as to the beneficiaries of Article 3.2 in that case?
Brother, half-brother and nephew.
Yeah. Of our Bangladeshi national who married an Irish national.
And they got their family permits but were refused residence cards on the grounds that they hadn't proved that they lived with, as part of the family?
Yes.
Lived with Mr. Rahman's wife.
The question...
Before she came to the United Kingdom.
That is right. The questions put to the court appear at paragraph 17, MS 1592. And at a quick glance, the 6 questions come nowhere near to the questions that we are confronted with. But that's not the end of our case, because the point that I want from Rahman is that this child falls within the scope of the term beneficiaries within Article 3.2a. And if you turn to paragraph 67, MS 1600, at paragraph 67, he says that the clarification of the terms used by the directive, albeit by exclusion, in defining, albeit by exclusion, the scope, rationale, persona, or the facilitation obligation involves, in my view, an independent, uniform interpretation of the notions used in the provision to define its beneficiaries, irrespective of any margin of discretion. Pausing there, I don't think the Court of Justice went that far to reject, to endorse that view.
This is Advocate General Bott.
Yes.
But there's nothing in the court's judgment on this, or is
Or nothing that comes directly, that addresses directly the point that we are faced with. At 68, in my view, moreover, the margin of discretion according to the member states, and my Lord has seen the discretion vested on the member states under Article 3.2, is limited in 2 ways. First, in application of the criterion developed in Garcia Velo, letter C, the national measure at issue must not have the effect of unjustifiably impeding the exercise by the union citizen of his right of free movement and residence within the territories of the member states. It seems to me that such a serious impediment would exist if it were established that the union citizen was forced to leave the territory of the host member state, or even a forcible right to leave the territory of the European Union altogether. And then, in this latter situation, according to clarifications made by the court in Derici, there would also be a denial of the genuine enjoyment of the substance of the rights attaching to citizenship of the Union, which would entail recognition of a right of residence for family members. To the end of that paragraph, 69 is relevant to indicate the limit of the member states' margin of appreciation. And then at paragraph 70, he sets out the second limitation, which is subject to the observance of fundamental rights, in this case, Article 7. And then, if I could ask you to turn to paragraph 74, MS 1602, he says, the combination of the rights of residence attached to union citizenship and the protection of private and family life, so he has both those limbs added, as implemented by EU law, may therefore effectively establish a right of residence for members of the families of the union citizen. This right need not, it seems to me, be reserved for the closest family members. That's Article 2. Whilst Article 8 of the Convention of Human Rights guarantees only the exercise of right to respect for an existing family life, and whilst it has been held in the specific area of entry, residence, and removal of non-nationals, that family had to be limited to the core family. the European Court of Human Rights nevertheless generally adopts a broad conception of family life characterized by the presence of legal or factual elements, and I stress those words, legal or factual elements, pointing to the existence of a close personal relationships, which makes it possible, for example, to include, under certain circumstances, ties between grandparents and grandchildren, ties between brothers and sisters, even de facto relationships lacking any blood ties, which have been regarded as constituting family life. And in my view, the principle of non-discrimination does not allow the definition of family with variable geometry depending on whether the members of the family of the union concerned are themselves union citizens or nationals of a non-member country. In defining the scope of the fundamental rights of private and family life, the notion of family life also cannot vary according to the more or less strict definitions under the provision of secondary law. 77, I conclude that the fundamental right to private and family life may in principle be relied on by all categories of persons mentioned in Article 3.2 of Directive 2004. So we respectfully submit, even though it may not appear too clear from these paragraphs, that the term other family life in 3.2a has a degree of flexibility, and if there are present legal or actual elements pointing to the existence of a close personal relationship, then those are indicators that there might exist family life between persons, although there is no blood link.
Right. What he's dealing with is whether domestic legislation is entitled to narrow the categories of other family member, isn't he? By the look of it, the decision in the court was not so much about that, but about whether the member state was entitled by its domestic legislation to impose particular requirements which the other family members had to satisfy. In this case, a period of dependence in this particular case. Is that right?
Yeah.
And am I right that they upheld the power to do that?
My lords, they said yes, but they provided the specific answers which I'll take you to, but I have accepted that the questions framed in Rahman do not come near to the questions that we are confronted with. But there are passages in the Advocate General's opinion which add some support to our propositions.
I understand that.
I mean, basically, your argument is that there's a limit to the margin of appreciation when it comes to the definition of categories. Whether you can be included in those categories and whether you meet the criteria for inclusion in the categories, that is something that the national authorities or the member states can impose. But so far as the categories are concerned, there is a restriction on the margin of appreciation.
That is right. And they are subject to those two limitations.
Yeah.
Should not impede the rights, the freedom of movements, and observance of human rights.
Did the definition of the categories actually arise in Rahman?
The answer to that, I think, is not. I'll be corrected.
I don't think so.
Because if one turns
They're plainly within the categories. I mean,
yes,
this was an entirely incidental observation by the
a half-brother, a nephew, and so forth fell within the categories. But the Court of Justice, the nearest that I could find which touches on it, is at paragraph 21, MS 1614. And the words that I stress on the last two lines, on applications submitted by persons who have a relationship of a particular dependence with a union citizen. And to come to the conflict between my learned friend's submissions and ours, what they say is, look, if you have a legal definition of a family member, and there's a legal recognition of who is a son or a fully adopted, meaning an adopted child in accordance with international law, that person would fall within Article 2. But if you extend that meaning to those who are not recognized as adoptive children, but are treated under the kafala system as the child of the family, that's legal fostering. However, that relationship would not fall within under Article 3.2a, because it would have the effect of undermining Article 2. The Commission's view with reference to Article 2 and Article 3.2, the communications between the Commission and the European Parliament, is found at tab 10. And it commences at MS 721. It concerns their interpretation of the directive. And if you turn specifically to page MS 724, if I could point out, for purposes of Lord Reed's question to me, that midway through, under paragraph 2.1.1, the second last paragraph, they deal with durable partners. That's Article 3.2b. With reference to family members in direct lines, 2.1.2, they say this: without prejudice to issues related to recognitions or decisions of national authorities, the notion of direct relatives in the descending and ascending line extends to adoptive relationships or minors in custody of a permanent legal guardian, foster children, foster parents who have temporary custody may have rights under the directive depending upon the strength of ties in the particular case. There is no restriction as to the degree of relatedness. National authorities may request evidence of the claimed family relationship. Now, pausing there, of course, we haven't obtained permission with reference to Article 2. We are dealing with Article 3. They go on to say, in implementing the directive, member state must always act in the best interest of the child, as provided in the UNCR November 1989, 2.1.3. Article 3.2a does not lay down any restrictions as to the degree of relatedness when referring to the other family members. And then the rest of the paragraph doesn't really help. It deals with financial and emotional dependency. So we don't get very much assistance by way of reference to Article 3.2a, but we do get some assistance by looking at the definition of family members under Article 2, and it would seem to suggest that it extends not only to adoptive relationships, with a footnote 13 referring to Article 8, but to minors in custody of a permanent legal guardian. And that's the reason why I had drawn attention in our case, written case, to one of the international instruments, to that's paragraph 50, MS number 83, to one of the resolutions of the UN, which speaks of the permanency of the relationship being a suitable arrangement between the kafil and makful.
But, I'm sorry, Mr. DeMello, that would get you into Article 2, wouldn't it?
We started the
If
case
you're right.
on the basis that we fell within Article 2, but we got short shrift.
Right.
We didn't get permission, yes.
Mr. De Mello,
Yes.
This is rather an arresting paragraph that you've referred us to under 2.1.2. Is the Commission suggesting that minors in custody of a permanent legal guardian and foster children are direct descendants for the purposes of Article 2.
That was my understanding. That was my submission to the Court of Appeal. There was interest from Lord Kitchen, but certainly not from Lord Justice Laws.
Well, what it might be doing on the grammar is suggesting that minors in custody of a permanent legal guardian are, and then going on to say that foster children may have different rights under the directive. In other words, they might, but it might be either. And either way, as my Lord says, it's quite arresting, isn't it?
Well, but this is why I took some trouble, Mr. Moomin and I took trouble by referring you to the international instruments, which seems to shape a particular significance for those kafala children called makfuls. And because many countries do not subscribe to the Hague Convention on Adoptions, so they found that adoptions wasn't a ubiquitous universal solution for all children. And what happens to these children? And we cited an Italian Supreme Court case which says to exclude them would amount to discrimination. We've not run a case based on discrimination. Our case is quite simple. We fall within Article 3.2. We don't fall under Article 2.2. We haven't got permission with reference to Article 2.2, but indeed the communication from the Commission is arresting, and that in itself might mean that the matter is not acte claire.
So maybe we have two questions to refer to, Luxembourg,
Yes.
or even three.
I'm not sure which is the third one. Oh, yes, I see. Yeah,
Well, one would be 2-2.
3, and
One
then
would be
the Salah
3-2,
point.
yes.
Yeah,
And the third one would be the jurisdiction point. Yes.
that is right, yeah. I think if I say any more, I'm wasting my breath, because I think I've analysed
do
the
that.
situation. Lord Reid put the point to me. I've come to Article 3.2. And yes, I should point out Mr. Moomin kindly through his researches. I've referred to the Italian case. I should just point out, and for note-keeping purposes, the Italian Supreme Court's case is referred to MS 81, paragraph 44. Unfortunately, we attempted to get a translation of that case, and it seems it might be available next week. But there is an extremely elucidating article written analyzing the case in the Italian jurisprudence, which is in our second supplementary bundle and tab 23. May I, not at this stage, invite you to read that case because it makes 2 points. I'm not inviting you to do so now, but point number one, because as my lady and lords know, that there are a lot of Moroccans, Italians residing in Italy, and they subscribe to the same type of adoption systems, I call it adoption systems, fostering systems, as Algeria. And firstly, they took note that it would be wrong to simply disregard the judicial pronouncement of kafala, and secondly, that such a child could be treated as a family member, having regard to the citizenship directive and the communications made between the Commission and the Parliament. So it may be that your brother, sister judges sitting in a different plane regard such children as children who could be considered as family members. And my closing submissions would be this. There's nothing in international law, there's nothing in the Strasbourg authorities which we respectfully submit suggests that such a kafala child who doesn't seek recognition as an adoptive child in accordance with international law, national law, cannot be treated as a family member for purposes of reunification. The child and their parents are not seeking adoption as we understand it. It's against their religious norms or mores to want to adopt the child in accordance with a scheme which is contra to their innate religious belief. And it would be wrong for us to enforce upon them in a Procrustean way that they, those children and their parents, should fit the bill. And that's totally anathema to them. I think that is all we have to say by way of submissions, but if there are any other questions on the interpretation of Article 3.2?
Yes, I'm
it's
sorry.
not clear.
Are you going to talk at all about the Adoption and Children Act?
The answer to that is no, because we've never put our case on the basis that this is a child who's brought into this country for purpose of adoption.
No one's suggesting that. The question is whether she has been brought, it would be brought in having been the subject of an external adoption as fairly broadly defined in Section 83.
If our response to that in the written case and down below, that Section 83 would have no purchase and
Simply doesn't apply.
Doesn't apply,
Okay.
and you disapply it if it was incompatible with EU law. I hope that answers Lord Hughes' question.
Thank you.
Because that was one of the grounds of refusal, and we dealt with it. But really, we've always made it plain that this is not a child seeking recognition as an adoptive child.
On that point, allied point, I wonder whether you could just go to your case, paragraph 94C, Mr. De Mello, which is on MS 102. Entry with a view to adoption under paragraph 316A of the rules also creates problems for Sarah because Algerian law does not permit adoption.
Yes.
Why does the fact that Algerian law does not permit adoption preclude Sarah from being adopted and preclude your clients from seeking her adoption in England?
My Lord, if it was simply a purely domestic immigration within the immigration law and our domestic adoption laws, I would have no answer to that. But the question that arises is whether that requirement by the United Kingdom imposed upon a child like Sarah, who's seeking under European Community law to join the father in this country, would, in our respectful submission, be incompatible with the freedom of movement provisions and Article 3.2.
So I don't think you're really defending the submission here that Algerian law as such would preclude an application for entry here with a view to adoption.
Our submission is that, and I took you to the document which shows that Sarah can travel abroad, but the Article 46 of the Algerian Family Code prohibits adoption. The parents gave written evidence that their choice is to have a child from their own background, and they themselves would not like Sarah to be adopted because that's their adherence to their faith.
Well,
The other answer is that you've submitted to Algerian law in order to achieve the current status, and it wouldn't be keeping faith with that submission to it to then act in defiance of the interdict in Algerian law that forbids adoption.
Yes.
Well, hang on. Was that the evidence, Mr. De Mello? It may have been, but it's not as it was recited in the first-tier tribunal. The first-tier tribunal's recording of the evidence of the father was that he'd thought about adopting in England, hadn't done a great deal of research, but had looked at the internet, came to the conclusion it was all rather difficult, and thought that it would be very much easier if he and his wife went to Algeria and adopted there. Was that the evidence or wasn't it?
No, that's not entirely correct, because what he said in his witness statement and her witness statement...
Well, he gave evidence, didn't he?
He did give evidence,
Yes.
and I'll come to that, because, number one, as I reminded you, that Senior Immigration Judge Allen didn't find this a case of abuse. Second, what he said, if you turn to... and remind me, Skeleton, at MS 325,
Well,
it's paragraph 8, then it's paragraph
well, that's certainly what he
11.
said there, but look at the first tier tribunal,
MS
158. Paragraphs 14
Yeah.
to 16.
And he was asked why it was stated in the report it's important for him to adopt a child from Algeria because of her heritage. Just pausing there, and I think that's a reference to Ms. Brown's report. His reply was that it's easier to get her from back in Algeria than here in London. Here they tried and found it very difficult. Asked again about their heritage. And now just pausing there, if that is being suggested that he didn't meet the conditions for adoption, that would be a different matter. If it's being suggested that he couldn't find an Algerian child to adopt, that itself is different.
Sorry, I didn't understand that.
Well, if he found it difficult because he couldn't, for any reason, meet the domestic criteria for adoption, as opposed to finding a suitable Algerian child, because he made it
Oh, I
clear.
see.
What he said in his witness statement, he wanted somebody from his own heritage and background, and the wife's witness statement.
I follow.
I read it initially in the way that my Lord has suggested it, but that's not our understanding. And it was for that reason I drew your attention to the immigration
Yes, I
judge's
follow.
abuse. Also, I must point out that the skeleton argument that we submitted before the FTT, MS 227, which paragraph? We said at paragraph 11, to make it absolutely clear, that this was not a case of where they were seeking adoption. And I think that point was misunderstood, perhaps, because by the FTT, because we repeat that at paragraph 37, MS 233. And if finally, if I could just ask you to look at SSB number 257.
Are we leaving the first tier tribunal
I am, yes.
decision? Could we just pause briefly at paragraph 35 on MS 162?
162.
No reason has been given by the sponsor for not approaching the authorities in the UK with a view to obtaining a certificate of eligibility. He'd sought to bypass the normal requirements by adopting abroad without even speaking to social workers. I find this is an issue of choice. It was a choice they made, having learned it was easier to obtain custody of a child in Algeria than it would be in the United Kingdom.
Firstly, we never made out a case that this was a case where he was seeking to bring a child for adoption. Secondly, that's an inference that she drew, the FTT judge drew, that this was done. It was a choice they made, having learned it was easier to obtain custody of a child in Algeria, is an inference which she drew. And thirdly, there is simply no reference to the rigorous assessment that I drew your attention to, the 18-month period and so forth. But I come back to what the upper tribunal said. This is not a case where there has been a suggestion of abuse. This is not a case where community rights have been used in a way to circumvent national law, which constitutes an abuse. This is a case where there is a loving relationship between a child with a degree of permanency, where the judicial kafala has been pronounced, there has been a name change, an assumption of parental responsibility, and several other factors. So the upper tribunal were correct to say, having regard to the term other family member and Article 8, They fell fairly and squarely within that definition.
Thank you. Now, you wanted to go lastly to...
I was reminded that in our second supplementary bundle, and for note-keeping purposes, SSB page number 257, that kafala was set up to deal with the case of abandoned children. And this speaks of the Moroccan law, but the Algerian law is similar to the Moroccan law in that regard. And it's SSB number 257, and it's the second last paragraph.
I'm sorry, page?
257 SSB, and it's the second last paragraph.
Well, that's in the article we're going to be reading anyway.
That's right.
Pursuant to your invitation.
Yeah.
Very well.
Unless I can assist you further, I think I've taken up my time. My lady, those are our submissions.
Thank you very much indeed, Mr. de Mello. Mr. Milwyn?
I'm very grateful. I have nothing to add. Thank you.
Mr. Kennelly.
My lords, my lady, if I may begin by just clarifying precisely what is in issue in this appeal. The only issue in this appeal is whether the Court of Appeal erred in holding that Ms. Medouni was not an other family member of her sponsor, Mr. Medouni, within the meaning of Article 3(2)(a) of the directive. The question of whether Article 2(2) of the directive applies to Sarah is not before you. In summary...
Well, supposing that we decided that we needed to look into that in the light of the Commission's opinion to the Parliament, you would say that the Court of Appeal were right for the reasons they gave.
Indeed. My lady understands, of course, permission wasn't given for the...
I know, but that doesn't stop us.
No, I'm well aware of that, my lady, and you're quite right with respect that we would revert to the Court of Appeal's analysis, and I shall come in due course to that communication from the Commission. There's a critical first sentence before the passage which your lordships and my lady examined, which I think throws some light on what the Commission said, and which is not, of course, a source of law in any event.
But presumably if Sarah had been adopted, she would be within 2(2)(a).
Yes, if she'd been adopted pursuant to the procedures.
She'd be a direct descendant.
Absolutely, and that's central to my core submission about the distinction between Article 2(2)(a) and Article 3(2)(a). But in summary, we submit that the Court of Appeal did not err, first because the distinction, this is my Lord's point, the distinction between a family member in Article 2(2) and an other family member in Article 3(2)(a) is one of proximity in fact to the EU citizen. Second, although Sarah could in principle be a family member within the meaning of Article 2(2), if she were adopted in accordance with the procedures recognised by UK law, she has not been adopted in this way. And accordingly, she fails to satisfy the conditions of Article 2(2). As I said, that finding isn't under appeal, although I hear my lady says about that. But the key...
And does it follow from that that, this discussion I find rather strange, to be honest, in the FTT about effectively going for the easy option is really all beside the point. If she had been adopted, there wouldn't be any debate about all this. She would be within a different article of the directive.
If she'd been adopted in accordance...
If she'd been adopted and it had been an adoption recognised in this country.
Absolutely. If she'd been one of the 5 avenues, and I shall come to those, because it's perfectly possible, it was perfectly possible to have adopted Sarah in accordance with UK law. There's a finding of fact which is unchallenged, that there was no obstacle to adopting her in accordance with the procedures recognised by UK law. Had that been done, she would be a family member under Article 2(2) of the directive.
You said there was no obstacle. There was the obstacle of the sensibilities of the parents.
Yeah.
Well, my lord, I don't get my submissions out of order, but I shall come. There's a finding of fact, again unchallenged, that Mr. and Mrs. Medouni tried to adopt in the English system. That's a finding of fact in the FTT determination, and findings of fact were made about the fact that ultimately it was a matter of choice for them not to pursue the UK procedures, which are very rigorous and stringent.
Well, tried is overstating it a bit, isn't it? Looked into.
Well, indeed. But there was no... certainly
Vaguely investigated.
Yes, quite.
no suggestion that there was an absolute
But
bar
it's
to proceeding in that
arguably, I mean, you're entitled, I suppose, to say that it tends to suggest that there wasn't a rooted, principled objection.
way. Well, indeed. There are findings
What
of
if there
fact.
had been? What if there had been a principled objection?
Well, the only objection that's been raised in the appeal is the question of Algerian law, which goes nowhere in my respectful submission. That's no obstacle to Sarah being adopted under UK law.
Adoption belongs to a specific legal tradition. I mean, it originates in our tradition in Roman law. There are large parts of the world which don't have a concept of adoption.
Indeed, but the 5 avenues, the UK has 5 avenues for adoption, which are consistent and have been made pursuant to the United Kingdom's obligations under international law, which goes to the protection of the child. And as I shall come, when I analyse the directive, to the fact that what constitutes an adoption for the purposes of Article 2.2 of the directive is left to the Member States, and all of the Member States are parties to those international conventions.
And so you say that people who belong to a different cultural tradition, well, they don't have an institution of adoption, but instead have kafala, are automatically ruled out of court, so far as this directive is concerned.
The directive leaves the matter to the Member States. So the directive is silent as to what's required. The Member States...
Well, within the constraints of compliance with the Charter.
Indeed.
So you would say it's compliant with the Charter for the UK to elect to bar all children who have not been adopted but have been made the subject of guardianship arrangements in accordance with Islamic law.
Well, my Lord, as I shall come to the avenues for adoption, de facto adoptions are a basis on which a different form of adoption, one that isn't the kind of adoption one recognised ordinarily in English law, that kind of adoption is recognised under the immigration rules and does provide a basis for bringing a child into this country, which is treated as adoption for the purposes of our law, but it doesn't require the steps, the particular objectionable steps to be taken abroad. And there are, I shall explain in due course as to what a de facto adoption requires, but the UK regime is relatively liberal. There are several different routes to inter-country adoptions, and de facto adoption is one of them. And that is not the same as an Article Section 83 adoption, which complies with the 2005 regulations. And that de facto adoption route was not attempted by the sponsor in this case. So there are routes, my Lord, to accommodate cultural sensibilities, which I think is my Lord Kerr's issue also. But in order to say, even roughly within the 4 corners of the appeal, there's been no point taken that, certainly not before your lordships, that there's a question here of religious discrimination, that somehow requiring the sponsors to go through these avenues is discriminatory in any religious sense. That point's not been taken. There are findings of fact that there are no obstacles to adopting in accordance with UK legislation. But to come back, if I may, to my submissions. It's
always difficult, Mr. Kennelly. We take you all over the shop.
Not at all. It's enjoyable, if I'm allowed to say that. So, at least so far.
That's an incredibly benevolent observation.
The point here, though, is that, and we're dealing here again with the directive in Article 2.2 and Article 3.2a. And the point I'm trying to make is that Article 3.2a, in the scheme of the directive, is not a fallback provision for family members who could potentially satisfy the requirements of Article 2.2 but have failed to do so on the facts. Article 3.2a is intended to apply to more distant family members than the members of the immediate family listed in Article 2.2.
Of course, there is a bit of fallback in Article 3.2. There's fallback in Article 3.2b. The registered partner gets in under Article 2.2, the partner who's not registered but nevertheless has a durable relationship with the sponsor can get in under Article 3.2. So is there some difficulty for your no fallback, please point?
My Lord, no, with respect. In fact, we adopt the point my Lord makes. We say that special provision for a durable partnership makes my point. That where it is necessary to create a fallback, it has to be done expressly. That's the point. Article 3.2 is not designed as a fallback. It's designed to apply to more distant family members. And where the community legislature decided that it was necessary to create a fallback, it had to do it expressly. And that's why I make the point which my Lord made to my learned friend, that if my learned friend's submission is correct, there's no need for Article 3.2b. That person would be a family member, and another family member covered by Article 3.2a on my learned friend's submission. I shall come to my Lord's point about blood relatives. Article 3.2a is not restricted to blood relatives. But again, I shall come to that when I take you to the
So you're making the rather interesting submission that the closer the relationship is between a child and the people wishing to sponsor her into this country, the less likely she is to be covered by Article 3.2a.
Yes, indeed. Because that closeness, those relatives who are in that close relationship...
Because she ought to be adopted.
Indeed. Indeed.
Okay.
So we come then to the final question, which actually links to the point my lady makes, which is that EU law must be interpreted consistently with both EU and international law provisions which address the welfare of children. And in our submission, the appellant's, Mr. de Mello's interpretation of Article 3.2a, which requires member states to recognise custodial arrangements that do not satisfy the safeguards established in international law for the protection of children, again demonstrates why it is not appropriate under EU and international law to adopt that interpretation. Now, I propose to examine the directive first, and then the international instruments, which I hope to make good those broad introductory points. And turning to the directive, and I appreciate that the court has seen this already, but since it's central, it would be useful to look at it again. And that's in the First Authorities Bundle, tab 9. MS 675. And if I may begin with the recitals. Recital 5 is the recital that addresses Article 2.2. I don't propose to read that again. The court has read it already. Then, importantly, recital 6, and if I may, I will take this slowly because, although I know you've read it and it's been addressed already, this is a very important recital.
Yeah. Educational mission.
I will finish on time, my lord, if that's the court's concern. Recital 6, in order to maintain the unity of the family in a broader sense, and I emphasize the word broader, since this is the recital that addresses Article 3.2, and without prejudice to the prohibition of discrimination on grounds of nationality, the situation of those persons who are not included in the definition of family members, and who therefore do not enjoy an automatic right of entry and residence in the host member state, should be examined by the host member state on the basis of its own national legislation in order to decide whether entry and residence could be granted to such persons, taking into consideration their relationship with the citizen or any other circumstances, such as financial or physical dependence. That is, in our submission, demonstrates that Article 3.2 is designed not to address the closest relatives, but those who are family in the broader sense. And then, my lord, if you could turn to the substantive provisions, Article 2 begins on MS 683, and family member is defined obviously over the page. I shan't read this again since this is obviously very familiar to you, and I've already made the point, it's common ground, that an adopted child, adopted under national legislation, is covered, is treated as a direct descendant under Article 2 to C. Then Article 3 Without prejudice to any right to free movement and residence, the persons concerned may have, in their own right, the host member state shall, in accordance with its national legislation, and that's an important provision, facilitate entry and residence for the following persons. And it's any other family members, irrespective of the nationality, not falling under the definition in point 2, Article 2, who, in the country from which they've come, are dependents or members of the household, having their primary right of residence or where serious health grounds strictly require the personal care of the family member. Pausing there and taking the point my Lord Wilson made, there is no basis for restricting that to blood relatives. Any other family members includes blood relatives and relatives by marriage, the husbands, wives, partners of blood relatives.
Well, could it be restricted to consanguinity and affinity? Certainly there's no warrant for excluding affinity, but what about those two?
I hesitate, my lady, to adopt that limitation because it's drafted in very broad terms, and the provision provides a lot less protection than Article 2.2, but it is deliberately wide in order to do as much as it can to facilitate the free movement of persons, which is the object of the provision. So, my lady, if I may, if somebody pulls my jacket and tells me that I should adopt that, I will. But at the moment, I hesitate to.
I was only asking you a question. I wasn't
well
expressing any opinion at all.
The phrase is deliberately broad, and the important point here is that it's not limited to blood relatives, and that is why 3.2b is so important, because 3.2b demonstrates that where the EU legislature wanted to provide a fallback for a person who would ordinarily be in 2.2 but fails on the grounds of the national legislation, they have a special provision made for them in Article 3.2, which would not be necessary on the appellant's interpretation of Article 3.2a. Certainly nothing in the directive to suggest, and nothing in the recitals to suggest that Article 3.2a is designed to sweep up other close family members who are prima facie covered by Article 2.2, but who fail in the facts to satisfy the requirements of Article 2.2. And this approach to distinguishing Article 2.2 and Article 3.2a was adopted to an extent by the Advocate General Bott in the Rahman case. And again, although you've seen that, if I may take you back to it, that's in Volume 4 of the Authorities, tab 42. So the facts the court has already seen in the headnote. If I could take you to the Advocate General, first at paragraph 5, where he notes that the directive recognised in accordance with a graduated system rights of residence for family members, recognising in my submission the fact that there's this different tiers of protection depending on, in my submission, proximity to the EU citizen. And then, in terms of substantive analysis, the next relevant paragraph is 41, where the Advocate General addresses the first question, where the referring court is essentially seeking to ascertain whether Article 3.2 of the directive requires the Member States to take measures to facilitate entry and residence for other family members who are nationals and who can meet the requirement of Article 10.2, and if so, what is the nature of the measures required of the Member States. And at 45, at the bottom of that page, MS 1597, the Advocate General analyses first Article 2.2, and he notes first that although the directive has undoubtedly extended the scope personae of the right to family reunification for members of the family of the citizen, by including that category, defined in Article 2.2, the partner with whom the citizen has contracted a registered partnership is still relatively restrictive, since first, in contrast to previous legislation, it includes only direct relatives in the ascending line and direct descendants. And second, it makes recognition of state as a family member subject to conditions of age and dependency.
I suppose your argument would apply to guardians as understood in our culture also, wouldn't it? If you had an orphan, for example, who didn't have parents but had a guardian,
Yes.
then you would say that the orphan is not a direct descendant of her guardian, and she's not an other family member of her guardian's family either. Am I right?
I don't know the answer to that question. We've not considered the status of a guardian. I'll take instructions on that. But obviously, we already are implying into Article 2.2 the fact that an adopted child would be covered.
Yes, of course.
We do that by implication.
Yeah. Yes, but it rather sounds as if the same argument would be that because the guardian hasn't adopted his ward, he doesn't fall within either 2.2 or 3.2.
Yes, on the face of it, that would be correct. That person would not be treated as a direct descendant under Article 2.2. But I'll be corrected if I've got that wrong.
But what about Article 3.2?
Well, it would depend on the closeness of the relationship. If the person was the key question is, could that child prima facie come within Article 2.2? If not, then there may be some basis for saying that the child could come within Article 3.2a. That's not a situation like the appellant in this case.
I mean, if a guardian could adopt the ward, but chooses not to, then the relationship doesn't fall within 3.2.
No.
Is that what you're saying?
A guardian could always adopt, but why would they? I mean, they've got parental responsibility anyway.
Yes.
They may be guardians precisely because they don't want to interrupt or change the family relationships of the child.
Yes.
They don't want the child to become a member of a different family.
Yes.
But nevertheless, they are responsible for the child, they're looking after the child's living with them. So why would that person not fall with it? Why would that child not fall within Article 3.2a?
Because, well, on the basis of the submission I've made to you, because the option of adoption is there in order to come within that degree of closeness that Article 2.2 requires, and a choice has been made not to take that step and therefore come within Article 2.2. This is subject...
Is closeness to be defined as a matter of legal formality? Yeah, on that argument, it rather appears that it is.
Well, the categories in Article 2.2 are quite tightly limited. There's reference, as the Advocate General notes, to direct descendants and direct ascendants, and direct relatives in the ascending line and direct descendants. So the EU legislature has made a deliberate choice to limit the category in Article 2.2.
Well, so you say, but the Commission obviously understand it as having a much wider meaning, which would cover the guardian.
Subject, my lord, to questions of national law, because the provision since we've referred to it, perhaps it's useful to take up that now. The guidance is in tab 10. In which volume is that? Authorities, Volume 1. And at MS 724, one sees the reference to family members in the direct line. And the sentence upon which I place particular reliance is the very first sentence, the very first part of the sentence in paragraph 2.1.2 at the bottom of page 724. Without prejudice to issues relating to recognition of decisions of national authorities, the notion of direct relatives in the descending and ascending line extends to adoptive relationships or minors in custody of a permanent legal guardian. So perhaps...
Members custody of a permanent legal guardian. And that's expressed as an alternative to those in the adoptive relationships.
Well, there the Commission appears to be, forgive me, I hadn't appreciated that was there. The Commission there appears to be saying that that is akin to the adoption, and provided it's satisfying the national legal requirements, that would be good enough to qualify under Article 2.2. Is that fair? So, my Lord, the Commission there, as I said, is discussing, there's no doubt, discussing Article 2.2 in that context, not Article 3.2a. And importantly, it's subject to recognition of decisions of national authorities. But it does say that subject to that, the question of direct relatives can be extended to adoptive relationships or minors in custody of a permanent legal guardian. There's no question of that person, that child, being covered by Article 3.2a. That's the point. And no suggestion here that if the particular child failed to comply with the relevant national requirements, there would somehow be a basis for accommodating that situation under Article 3.2a instead. That's not contemplated by the Commission in this guidance.
And what do you make of the next sentence?
Well, I think, my Lords, perhaps it was Lord Hughes very fairly acknowledged that that is not clear. It's not clear that that next sentence is describing a situation outside Article 2.2.
No, but if it isn't, what part of the directive does the Commission have in mind in that sentence?
It can only be Article 3.2, can't it? If it isn't talking about 2.2.
Unless there's anything else anywhere about fostering.
It is unclear. I mean, it's not in my submission clearly referring to Article 2.2. It's not referring to Article 3.2. I understand what the lady's saying. It must, logically, one assumes it must be referring to.
Well, it's not referring to Article 2.2. It must be referring to Article 3.2, surely.
Well, my Lord, seeing where it's placed, where it's placed in this document, in the section under family members in the direct line, it's not in the section under other family members. Although it's not clear, if it's to fall anywhere, it comes under Article 2.2.
So Article 2.2, I mean, if that's the Commission's view, there must at least be a respectable argument that 2.2 is given a much wider meaning than has been assumed in the discussion.
Well, as I say, at the risk of repeating myself, this, of course, is all subject to national requirements, but certainly my submission would be, although it's not clear, it does appear to be in Article 2.2, not Article 3.2a. It has been placed here in my submission clearly in a section which is addressing Article 2.2 and not Article 3.2a. And again, I come back to the point which I submit supports my primary submission, which is that there's no suggestion that if the foster child or the foster parents have failed to comply with national rules, they can be accommodated by Article 3.2a. The Commission's view appears to be that they can...
There are two quite distinct points in this case, aren't there? You're on the first at the moment, but the first is whether a keffala, a child subject to a keffala arrangement is capable of being within Article 3.2a. Yes?
Yes.
The second is, if she is, are the restrictions which this country places via its own regulations with a view to maintaining some sort of control of custodial arrangements for children legitimate or not?
Yes. Yes, and as I said at the beginning, I'm addressing first the structure of the directive, and then we'll turn to the international instruments, which must be an aid to interpretation of the directive. In addition to the charter points, which my Lord Reid mentioned, which also address the rights of the child.
Sure.
But it's critical that I do address this issue about the importance of protecting children in inter-country adoptions and the importance of having rigorous and stringent procedures in place. And as I shall explain, the rights of the child are paramount, and that involves making sure that where there's an inter-country adoption, the adoption in question is properly scrutinised by the competent authorities. But I'll come to that when I come to the instruments themselves.
I'm afraid I don't understand this. The child Sarah's parents, in inverted commas, have guardianship of her under Islamic law by virtue of an order made by under Algerian law, by virtue of an order made by an Algerian court.
Yes.
Nothing the Home Secretary does is going to alter that.
No, but the Home Secretary, before the Home Secretary permits an inter-country adoption, is required properly to scrutinise how custody was obtained in Algeria.
But nobody's asking for an inter-country adoption.
But the point here is that if Article 3.2a is interpreted in the way that my learned friend suggests, it's a way around the protections which are there for inter-country adoptions. It will encourage people to, and I don't suggest for a moment this is what's happened in this case, but this is a question of legal construction. It will weaken the protection which is there under the current adoption laws, because it will encourage people to go to jurisdictions where perhaps the standards are lower and argue then that although they can't comply with the adoption protections in this country, that they have the protection of Article 3.2a, and their entry with the child should be facilitated by the member state.
I mean, some of us are clearly having difficulty with your repeated reference to inter-country adoptions. Maybe when you come to the relevant material, you had better widen it out to these rigorous procedures that we have in this country before we let any non-natural child live with other adults.
Yes, and I shall, as I keep saying, I shall come. First, when I get through the structure of the directive, I will come to the protections which exist, and the important point that de facto adoptions are available to accommodate cultural sensibilities. That's one of the avenues which was addressed in the India case. But remaining, if I may, with the Rahman case and Advocate General Bott, and turning to where he actually addresses the substance of the difference between Article 2.2 and Article 3.2. The point I'm trying to draw from his opinion is that paragraph 52 of his opinion, and here he's addressing the extreme and more narrow ways of interpreting Article 3.2 that we don't need to go into. But he does say that in the fourth or fifth line down in Article 52, in paragraph 52, it is clear from these provisions, Articles 2.2 and 3.2, that the European Union legislature intends to draw a distinction within the family of the Union citizen between the closest members who have an actual and automatic right to enter and reside in the territory of the host member state with the Union citizen, and the more distant family members who do not enjoy an individual right of entry and residence under the directive. And then he describes what facilitation involves at the end of that paragraph. Similarly, over the page of paragraph 57, when he's talking about what Directive 2004-38 requires, he says that member states shall facilitate entry and residence for members of the family of the Union citizen not falling under the definition of nuclear family. Again, he plainly has in mind the notion that Article 2.2 covers the immediate close family members, and Article 3.2a is intended to cover more distant family members, family in the broader sense. And then over the page at 64, in relation to the content of the right, he notes that this is in relation to a submission made that there should be a presumption of admission where Article 3.2a applies. He describes the difference between the automatic guaranteed right under Article 2.2 and 3.2. The latter, he says, is formulated in general terms allowing each member state enormous latitude, the extent of which is further accentuated by the express reference to national legislation. And my friend is already taking you to the statements of the Advocate General in relation to the limits on the member state's margin of discretion, so I shan't repeat those. And then going on to the court, although the court says a lot less, as usual, about these matters, it doesn't disagree with the Advocate General paragraph 19 on MS 1613. The court says, as contended by the government, it follows both from the wording of Article 3.2 and from the general system of the directive that the legislature has drawn a distinction between union citizens' family members as defined in Article 2.2, who enjoy the rights set out there, and other family members envisaged in Article 3.2, whose entry and residence is only to be facilitated by that member state.
I'm sorry I keep interrupting. I don't want to take up your time, but there's quite an interesting passage in the Advocate General, paragraph 67, where, as I read it, he's suggesting that the expression other family members should be given an independent and uniform interpretation.
Yes, and that on its face is consistent with the well-established principles of EU law that unless national law is expressly invoked, the language must be given an autonomous EU law interpretation.
Yeah. So what's meant by other family members should be understood in the same sense in France, for example, as it is in, or Italy, as it is in the UK?
In principle, yes, the categories, which is why the member state doesn't have a discretion about the categories. But once the categories are established, the member state does have a discretion and a very wide discretion, as the Advocate General said, as to the conditions which the member state would impose for the purposes of admission and residence. That's the important distinction. In terms of the court judgment, if I may briefly take you to paragraphs 20 and in particular 21. In view of the time, I will simply leave those references with you.
Well, we've certainly read paragraph 21.
The next document I was going to take you to was the Commission communication, but we've looked at that, and I see the point, and I apologise for not anticipating the point about the Guardian, but ultimately I rely on the fact that it's covered in that communication under Article 2.2, because that makes good my point that that distinction which I seek to draw between 2.2 and 3.2a is borne out by the Commission's communication. There's no suggestion in the Commission communication that 3.2a can be a fallback for people who, pursuant to national procedural requirements, fail to satisfy the requirements of Article 2.2. That was the submission ultimately adopted by the Court of Appeal in this case. And if I may conclude in that respect, before I turn to the international instruments, by referring you to the Judgment of Lord Russell's Laws and paragraph 27. And if I may, if you'll indulge me for a moment, to very briefly turn to that. It's in the core bundle behind, it's in MS 148. And paragraph 27. I turn now to the question of the rights and the best interests of the child. And I begin, and I understand the point that the court is not limited, but I do begin with the position that certainly the current unchallenged situation is that under Article 2.2 of the directive, it's common ground, or at least it's not open to, it's not an issue now, that, it's common ground. It's common ground that direct descendants obviously include adopted children. That's not in dispute. But as I said before, the directive does not stipulate what forms of adoption count for this purpose, and that is left to the member states. And this is my point I was trying to make a moment ago. The Court of Appeal found that Article 2.2 of the directive does not require member states to treat all inter-country adoptions or their equivalents as giving rise to relationships of direct descendancy, irrespective of the procedures followed in the countries from which the child was sought to be adopted. That was not the finding in the Court of Appeal under Article 2.2, which, until I'm told otherwise, is still not before you. And member states are permitted not to recognise inter-country arrangements for the purposes of Article 2.2, where they, in the member states' view, fail to comply with their domestic arrangements, which themselves implement important international instruments designed to protect children. And this, in my submission, is consistent with EU law. An EU measure, as my Lord Reid said, must be interpreted consistently with the EU fundamental rights in the Charter and the international instruments. And if I may take you briefly to the judgment of the Court of Justice in the European Parliament and Council of the European Union case. That's behind tab 29 in Volume 2. Volume 2, tab 29. This was a challenge by the... Oh, sorry, I got it wrong.
This is the Parliament against the Council case.
Yes. Yes. This was the European Parliament's challenge to the Family Reunification Directive. The Parliament contended that it gave insufficient protection, I'm paraphrasing, but insufficient protection to the rights of children. And if I could take the court to MS page 1162, which refers to the rules of law in whose light the directive's legality may be reviewed. At paragraph 31, the court refers halfway down that paragraph to Article 24 of the Charter, devoted to rights of the child, which provides in paragraph 2 that in all actions in relation to children, whether taken by public authorities or private institutions, the child's best interests must be a primary consideration. And in paragraph 3, every child shall have the right to maintain on a regular basis personal relationship and direct contact with both his or her parents, unless that is contrary to his or her interests.
Yes, yes, that's very well known. You're suggesting that this child shouldn't have that right.
My submission is that in order to vindicate the best interests of the child, which is the paramount consideration...
No, primary consideration, not paramount.
And indeed, my lady, it's a primary consideration. But that is vindicated by the rigorous adoption rules which the member states are permitted to have, and which they are required to have under the United Nations Convention for the rights of children. So, and forgive me, this judgment simply sets out, I think, which is well known to your lordships, which is that under EU law, the directive must be construed consistently, not only with the Charter, but also with instruments of international law, including the Convention for the Rights of the Child. And what are those instruments? But if you could go first, please, to the United Nations Convention for the Rights of the Child and paragraph 21. That's in Authorities Bundle 1, tab 1. And I think and this, my lady, I think is where I was actually getting the reference to the paramount consideration. Because in Article 21 of this convention, which is at MS page 432, one sees that states parties that recognise and or permit the system of adoption shall ensure that the best interests of the child shall be the paramount consideration. And they shall ensure that the adoption of a child is authorised only by competent authorities who determine, in accordance with applicable law and procedures, on the basis of all pertinent and reliable information, the adoption is permissible in view of the child's status concerning parents, relatives and legal guardians, and that, if required, the persons concerned have given their informed consent to the adoption on the basis of such counselling as may be necessary. B, there's the recognition that inter-country adoptions may be considered as an alternative means of child's care. And then critically C, ensure that the child concerned by inter-country adoption enjoys safeguards and standards equivalent to those existing in the case of national adoption. And it's a statement of the obvious that these protections, and the best interest of the child being the paramount consideration, are particularly important in inter-country arrangements because of the risk of abuse, such as child trafficking and so forth. And that is made express in the Hague Convention on Protection of Children and Cooperation in respect of inter-country adoption, behind tab 3 in the same bundle. That's MS 467. And if I may begin at the beginning with the reference in the recitals to the parties being convinced of the necessity to take measures to ensure that inter-country adoptions are made in the best interest of the child and with respect to for his or her fundamental rights, and to prevent the abduction, the sale of, or trafficking children. And the objects of the convention are set out in Article 1. And if the court just could read those to yourselves. And this is directly relevant in EU law, not only because of the points made by the European Court of Justice, but it's also recognised by the Commission. And in the guidance that we've been looking at already, at tab 10 of the same bundle, MS 725, you'll see a reference to the fact that and again, this is in relation to Article 2.2, this is under the heading Family Members in Direct Line. In implementing the directive, Member States must always act in the best interest of the child as provided for in the United Nations Convention on the Rights of the Child of 20th November 1989. That, my lords, in the context of a discussion about adoptive relationships, where the reference in the Convention under Article 21C is that the levels and standards of protection must be equivalent to those in the national system. So,
do you say that this arrangement, the arrangement in this case, would be covered by the Hague Convention?
no.
It wouldn't?
No, Algeria is not a party to the Hague Convention.
Well, I'm sorry, no, that wasn't my question. But you're quite right to pick me up. I appreciate they're not a party. What I mean is it an arrangement which creates a permanent parent-child relationship?
Yes, of course. I mean, it could do.
What's said against you, you see, is that this isn't an adoption at all.
Yes. Yes, I understand that. But the point is that it is open, unless I'm told otherwise, it is open to the parents in a case like this who do not wish to who do not wish to adopt the label of adoption, who may have powerful cultural reasons not to do so, to bring the child in by way of a de facto adoption.
Yes.
I mean, putting to one side...
Do you not think it's time you got on to de facto adoption?
Yes, forgive
because
me,
frankly,
yes.
that's your strongest point.
Yes. Well, if I may turn then to the avenues under MN in India. That's in the Court of Appeal at tab 221.
Where is it?
Tab 2, Authorities Bundle 2, tab 21.
Thank you. Yes. Yes, yes.
Second.
De facto.
Now, before I get into this, I'm going to see if I can fast track my submissions in view of my lady's comment. And
Well, I was trying to help.
no, I'm grateful. I'm grateful. I had a sense that that's where I had to go.
Tab 17.
So
You know, at the back of the court.
So, my lords, this is obviously Lord Justice Wilson, as he then was, and the reference is made to the 4 different avenues for entry under paragraph 13. And the second avenue is at MS 982, paragraph 15, described as that provided by paragraph 310, 6b of the rules, which we can come to. The reference there is to de facto adoption.
Yeah.
And the requirements are set out there.
So they've both got to live abroad
Yes.
for the 18 months prior to the application for entry clearance.
Yes.
And in the last 12 of those months, they've got to be caring for the child.
Yes. And the point's made against me by my friend that because of the requirements of Article 2 of the directive, that wouldn't work because it's suggested that the EU citizen has to be in the jurisdiction at the time, but that's not true. The directive provides that so long as the application is made 6 months before arrival at the jurisdiction, that satisfies the requirement. So there's no bar in the the regulations. Under the regulations, it is possible to make the application from abroad, so there's no contradiction between the position of the regulations and the ability to use this route for bringing a child in a kafala arrangement into the UK. That is treated as a de facto adoption.
So everybody agrees that in this case they can't meet 309A, but your case is it that 309A provides the avenue for someone who has either a principled or a practical objection to a formal recognised adoption?
Yes. Yes, indeed.
And would 309A catch the, for example, the testamentary guardian who's looking after the orphan children of an old friend?
In principle, yes. As I look at the requirements, yes.
Yeah.
But are you saying that if you meet paragraph 309A of the immigration rules, this qualifies as adoption for the purposes of Article 2.2?
No, my lady.
No, you're not saying
I'm
that,
not
are
saying
you?
that, no.
It provides, what you're saying is it provides a route for entry
Yes, it provides a route for entry.
independently
Independently.
of regulations 7 and 8.
Yes. So it addresses that concern, but it does not count for the purposes of Article 2.2 of the directive, for the reasons which I've given laboriously to you.
Not in the least laboriously.
That is the solution. And the immigration rules themselves are in the authorities bundle behind tab 17.
So how does this help us decide what Article 3.2a means? What you're basically saying, it isn't such a hardship because there's this way in.
Yes, yes, I am.
But it doesn't necessarily help us decide what Article 3.2a means.
No, it doesn't. It provides a route under domestic rules. And one must remember that under the system under Article 3.2a is subject to domestic rules. So there's a recognition that the member states have latitude.
That's the point, surely. We've all been looking at 3.2a as if we should take it entirely on its own. Isn't the correct? I mean, it's convenient to go to the directive. I'm not complaining about that. But the real question here is whether the regulations and the immigration rules between them create a situation in which there is an infringement of the directive.
Yes, as construed.
When the directive is construed in accordance with the Charter and other international obligations.
Indeed, indeed. I adopt that useful intervention.
What a surprise.
Yeah. So, the point is that as I said at the beginning, it would be inconsistent with the international instruments and the EU rules about which require the best interest of children, the child to be protected, to allow, under the guise of Article 3.2a, persons to get around the domestic provisions governing the intercountry arrangements for adopting children. And I say adopting with a small a, including de facto adoptions. And the present case is a prime example. And I mean no offence at all when I say this, but it's clear from the FTT's findings of fact that the process which was undertaken to obtain custody in Algeria did not entail the safeguards and protections equivalent to those one would see in a domestic UK adoption. And uncomfortable as it may be, those are findings of fact made by the FTT and upheld in the upper tribunal. And my lords have seen them. I shan't go back to them. But they are important because they demonstrate what the risk involved in adopting an interpretation of Article 3.2a, which is urged upon you. And then I turn really to the core point here, that if you're content to leave the Court of Appeal's finding under Article 2.2, the Court of Appeal found under Article 2.2 that the directive did not require member states to recognise such intercountry arrangements. It would be very surprising if at the same time Article 3.2a allowed a way for those arrangements to be recognised. That would be contrary to the underlying purpose of the Article 24 of the Charter and the other instruments which are sought to be implemented both in EU and domestic law. These are, as I said earlier, in terms of risk of abuse, the Article 3.2a right is very important. It's not as powerful as the Article 2.2 right, but it puts a third country national in a much better position than they would otherwise be. And if the appellant's interpretation were adopted, it would encourage prospective parents with EU law rights to adopt from states or to make arrangements with states with lower standards regarding child protection. They would not have to be exposed to the 5 avenues for bringing children into this country for the purposes of adoption or de facto adoption, in the knowledge that Article 3.2a would require the member state in any event to facilitate their entry. And it would encourage precisely the approach which we've seen in this case, where for reasons of choice, that is the finding, having found it difficult to do so in this country, an easier route was adopted by the sponsor. And that led the Court of Appeal in our submission correctly to conclude as it did at paragraph 26 of the judgment, which, if I may take you to very briefly. The point here is that if the respondent is not a family member within the meaning of 2, her case cannot be saved by appeal to Article 3 and Regulation 8. In the context of Article 2, the directive permits the member states to restrict the forms of adoption which they will recognise by reference to their reasonable apprehension of their international obligations to protect the interests of children. This is MS 148. It cannot be supposed that Article 3 then immediately proceeds to undermine or contradict that position by requiring other forms of adoption to be accepted for the purposes of the directive. In terms of the...
Have we actually looked at Regulation 8, Mr. Kennedy?
No.
No. I mean, I do realise that when we look at Regulation 8, we've got to see whether it is within the considerable latitude that the directive gives to national states. Perhaps it isn't. But for what it's worth, can we just briefly, if you've got time, look at Regulation 8, MS 763, look at paragraph 2, and would you please make a submission about what the word relative means?
My Lord, relative is not defined in the regulation, or in the regulations, or indeed in the directive. It is, again, in my submission, a deliberately broad word, broad to reflect the broad language in Article 3.2a of the directive. There's no dispute between the parties as to what it means. That's reflected in the written case at paragraph 8.
So let's forget kafala and come home and look at an ordinary foster child in this country, fostered by the local authority, placed with the local authority with foster parents. Would that foster child be a relative in your submission?
I mean, it would obviously, Your Lordship posits presumably some EU element that would trigger the regulations. The regulations are only relevant.
I'm talking generally about the word relative. Maybe it's got a special meaning here. We'd have to consider that. But stand above the regulation and the directive and tell me what your submission is about whether a foster child is a relative of the foster parents.
Well, this regulation, obviously, since it implements Article 3.2a, must be interpreted consistently with it. So the question is, could the foster child be adopted? Is there some way in which the foster child could come in under Article 2.2? And the way the Commission suggests, although very unclearly in its communication. If that's not the case, if it's not possible to come in under Article 2.2, and I don't mean because the legal requirements can't be fulfilled, I mean it's just not a legal possibility, it might be possible for the foster child to come in as a relative under Article 8.2. But the problem is that this provision is designed to deal with extended family members, and that has been understood, certainly in the guidance, to cover, affinity and sanguinity, as Mary said, not foster children. So there's never been any guidance to suggest that foster children are covered by Article 3.2a, and therefore would not normally be considered to be covered by Regulation 8.
So the logic of your submission is that it all depends on whether foster children could be adopted. If they can, and the foster parent elects not to adopt a child, then they're out of court because they've elected not to fall within their natural category, which is Article 2.
I'll have to take instructions because I've not considered this question of foster children, but unless there's something. The point is made to me that this perhaps is the answer, that ordinarily foster children are looked after for a limited period of time, whereas the concept of extended family members in the directive and therefore in the regulation presupposes a longer, more permanent.
Well,
There are plenty of foster children that are looked after for years and years and years.
Yes.
And in any event, that can't affect the point of principle, surely. The circumstance that in many cases fostering is a short-term business can't affect the question of principle.
Well, it could be that a short-term foster child is not a family member.
Yes.
A long-term foster child is a family member.
Yes. And
Entirely possible state of affairs, isn't it?
indeed, and I don't seek to make a bright line distinction, save that, and this is my primary submission that my Lord Reid made, repeated, was that if the only reason that one can't get into 2.2 is because of a failure to meet the national requirements, then one doesn't have access to Article 3.2a. It's not a fallback. But if the child in question could not properly be considered as an Article 2.2 candidate, then it may well be part of the extended family under Article 3.2a. And under Article 3.2a, the member state has a very extensive discretion as to how to apply its national rules. So I'm afraid, I apologise, I can't give the court any more guidance. There's no obviously case law on the point. The only principled basis I have for distinguishing is the one I gave at the very beginning, which is that there has to be a distinction between 2.2 and 3.2a. 3.2a is not a sweep-up. And one falls in one or the other, but not both, depending on the particular facts.
Well, if we're talking about foster children in the context of Regulation 8 of these regulations, then you are postulating, we would be postulating a situation, would we, in which an EU national who has fostered a child in his or her own country comes here and wants to bring the child with him or her. Is that it?
Yes. Subject to the requirements of dependency and so
Well,
forth.
it would depend hugely, wouldn't it, on the arrangements under which she'd been fostered, whether he was even permitted to do so by the home state. But that's a different question.
Indeed,
Yeah,
and
that's the situation we're contemplating. Right.
Indeed, and that's why the national legislative requirements are so important, because in this much looser 3.2a arrangement, the compliance with national requirements is even more important, because the concept of relative, reflecting the very broad reference to other family member, because that's so broad, it's even more important that the member states can exercise their discretion in the intrusive way that they do, in the way the Advocate General said they ought to do. Whereas Article 2.2 is much more strictly circumscribed, and the member state's discretion is more limited. I haven't, so that's Regulation 8. As you can see, subject to the difficulty in defining relative, and I've said what I can about that. That is not formally defined anywhere. In my submission, it's given a broad meaning, reflecting the broad meaning in Article 3.2a of the directive. But coming back, if I may, to my submissions.
Well, you have had your hour.
Indeed. Now, what I haven't addressed you are on the particular points that Mr. De Mello made. Those are my submissions. I've finished. But on Mr. De Mello's submissions, I refer you to my written case. I don't think there was anything new from his oral submissions that hadn't been made in writing, and we've addressed it in full in our written case. So unless I can give you any further assistance, those are my submissions.
Thank you very much, Mr. Kennedy. Mr. Lask? Thank you. Mr. De Mello.
Very short submissions. Firstly, dealing with Rule 309A, if you open it up at MS 857, Volume 2, tab 17, you'll see that first, right at the bottom, 309A, for the purposes of adoption under paragraphs 310, 316, a de facto adoption shall be regarded as having taken place if. Now, pausing there, they did not apply for entry clearance. They applied for a residence card under Regulation 12. And our submission was the immigration rules did not apply by reason of paragraph 5 of the HC 395, which is not in here. Secondly, going back to where I left, if you turn to 858, you would see that paragraph 10, 310, requirements for indefinite leave to enter the UK as the adopted child. And one of the requirements, because this would apply to de facto adopted children, is paragraph 310, subparagraph 7. One parent has the right of abode or indefinite leave to enter or remain in the UK. So that speaks of indefinite leave within immigration rules, and somebody might have permanent residence, and some EU citizen might have just a residence for 5 years. But the next requirements, and going to subparagraph 6, was adopted in accordance with a decision taken by administrative authority whose adoption orders are recognized by the UK, or is the subject of a de facto adoption, and 7, 1 and 2 apply, and it keeps going on, and 12 holds a valid United Kingdom entry clearance for entry in this capacity. So you would need entry clearance, and the other conditions set out therein in the immigration rules would apply. And we have submitted in our written case at paragraph 94 that really this would constitute, as found by the upper tribunal, an interference with the freedom of movement provisions. And our submission, written submission, is at MS 102. I'll ask you to read that at some point with reference to my learned friend's submission on para 309A. His reference to the case of MN, tab 21, that concerned an Indian adoption. India is a signatory to the Hague Convention. Algeria is not, so it has really no application in this case. The analysis of that case doesn't throw light on the interpretation of Article 3.2. The next submission in response is, my learned friend says, with reference to 309, there are no obstacles, and on the assumption that 309A applies, we of course say that first, under Algerian law, there was that obstacle. Second, it's their religious right. We have not made out a case of discrimination, but nevertheless it will be contrary to the best interest of the child if they were to depart from that shibboleth that they have pronounced in the judicial kafala in the court, that they said that we will bring up the child in accordance with the Islamic law principles and remain loyal to it. On that basis, you're free to travel. And my learned friend says, well, you can just pack that in a bag and throw it, jettison it overboard, and would compel you to enter the United Kingdom in accordance with immigration rules. Then my learned friend refers to recital 6, and one of the points I didn't draw your attention to, this is MS 676. I'll ask you to note the words other circumstances are broad enough to encompass a kafala type of, that's MS 676. Recital 6, the second last line, or any other circumstances. It goes on to say, such as the financial or physical dependence on the union citizen. It would be broad enough to encompass relationships such as the one that we have in place. Then my learned friend made a submission that if the kafala children are allowed to come into the United Kingdom through this route, it will encourage people to circumvent the national law. And may I just remind you what the Strasbourg Authority said for note-keeping purposes. The case of Wagner, which we cited in our written case, is tab 45, MS 1734, and may I ask you to look particularly at the paragraph cited on that page. And
Paragraph
132 and 133.
of your skeleton. Thank you.
No, of the case of Wagner, MS 1734, where the court says you need to consider the social reality of the situation.
Yeah.
And secondly, do not disregard the legal status validly created abroad. A similar point is echoed in the case of Harouj, which is paragraphs 48 and 50, MS 111. Sorry, 110, I beg your pardon, and it's paragraphs 48, 50, and 51. It's in, I beg your pardon, it's the second supplementary bundle, I beg your pardon, SSB, page 110, paragraphs 48, 50 and 51, the case of Harouj. Then my learned friend refers to the one of the international instruments at tab 3. Volume 1, he attached considerable significance to this document, which commences at page 467. Lord Hughes asked him, with reference to Article 2.2, what's the position of an arrangement which creates a permanent parent relationship? But if you look over the page, and because the Commission had regard to this, page 468, Article 4b, an adoption within the scope of the Convention shall take place only the competent authorities of the state of origin have determined, after possibilities for placement of the child within the state of origin have been given due consideration that an inter-country adoption is in the child's best interest. So our paraphrase of that provision reads that if you consider that the system of arrangements of legal fostering is in some way inappropriate, having regard to what goes on in Algeria, you still require the child's best interest to be secured through the adoption route, then the rest of the convention would apply. But that first prime consideration is that adoption may not be the best solution. We've made the submission in our written case. I think that covers what we want to say, but there are two articles which appear in our supplementary bundle, tab 26, for note-keeping purposes, SSB, page 327, and the earlier tab 24, SSB, MS 276, 277. Unless we can assist.
Thank you very much, Mr. D'Amelio. Well, we shall look forward to your submissions on the jurisdiction question in 4 weeks' time, and your reply to those submissions in 2 weeks' time. In the light of those, we will decide whether we require to have a further hearing in this case on the jurisdiction.
I'm most grateful. And if for any, I beg your pardon, I meant to say that if your memory sticks aren't good enough, we'll give you a new ones.
It's our shared drive that's not good enough, not the memory stick.
We can't
Well,
give you
new
a
memory
copy.
sticks are always welcome.
Yes, but new memory sticks are always welcome. A consolidated one would be very, very useful.
They're super.
Yes.
We will.
Rather than having four
yes.
separate ones.
I apologize for
Very
that.
useful.
Yes.
Thank you very much indeed. And in the meantime, we are grateful to you all for all your hard work on this case. We realise the written submissions are a great deal fuller than the oral ones. We have read them and we'll reread them before we make up our minds what to do about this interesting case. Court is now adjourned.